Under the basic rules of community property, property assets, excluding gifts and inheritance, that are acquired by either spouse during the marriage are community property. They belong to the marriage. Community property is owned equally by husband and wife. As long as it was acquired during the marriage, the name on the title is not controlling. Property held in the name of the husband is community property and belongs to the marriage. Likewise, property held in the name of the wife is community property and belongs to the marriage. Community property trumps joint tenancy, wills, and other legal arrangements. Both spouses have the right to buy or sell community property. The sale is simply a transfer of value from one form to another. A sale of a car is a transfer of value from the car into cash. Both the car and the cash constitute community property. A gift involves losing the value of the asset from the community property, and one spouse gifting community property away to a third party runs a risk of having the gift voided by the other spouse. Upon divorce, the value of the gift can be offset from the allocation of the spouse making the gift. So if the husband gives a $10,000 car to a friend, he effectively gave away half, $5,000 of the wife's property. On divorce, the husband will receive $5,000 less, and the wife will receive $5,000 more in an offset, aimed at compensating the wife for her loss of half the car's $10,000 community property value. The sale of a house, land, or any form of real property requires the consent of both spouses. Otherwise, the sale can be voided and the property can be recovered by the other spouse, with a refund to the buyer. Although both spouses have the right to all the community property, there are special rules for businesses. It may be in the interests of the success of the business that it's managed by one single person rather than both spouses. A business forming community property can be managed and controlled by one spouse. The spouse managing the business must account to the other spouse and must inform the other spouse in writing before the business is sold or liquidated.